Good morning and welcome. It is Sunday, July 26, 2026, and this is Sunday Fun Day from Courtroom Confidential, the fastest growing true crime news channel on YouTube. Thank you all so much for being here. Proud Grizzly, Kathy Mama Bear, Haley Moo, Pigeon Nest Tunes. That's how I'm reading it. The Crival. Thank you guys so much. I appreciate every single one of you for joining us on a Sunday morning or afternoon or evening, depending on where you are on the globe. To everybody who is new here, welcome. I would love it if this was somebody's first Sunday Fun Day. If this is your first time joining us on a Sunday, please let us know. Please say hello in the chat. Even if you're watching it on replay, send us a message. Let us know that you're here for the first time and let us know what you think of it. We really enjoy these Sunday Fun Days. Let me introduce myself to all of you people. On time, I'm here and I'm juiced. My name is Joshua Ritter. I'm a former prosecutor with the LA District Attorney's Office. I was there for 10 years before I left to go into private practice as a criminal defense attorney. And this is Courtroom Confidential, where we do our best to present to you both sides of the courtroom, both sides of the issues, both sides of the stories. And this is a show that we call Sunday Fun Day because we do it every Sunday. And what we do is you have left us voice messages throughout the week, questions that you've asked us, curiosities that you've had about true crime or the law or something that takes place in court or whatever it is that's in your head, and you ask us and we will answer them live here today. And you've asked a bunch of really great questions today. So thank you for that. Thank you all for making this show so wonderful. Now, I tried to get to as many questions as I possibly could. Obviously, I couldn't get to all of them. I tried to cover every topic that you guys were interested in, but if your particular question didn't get answered, please don't get discouraged. Don't take it personally. Just call in again and ask us another question. A lot of questions about Lindsay Clancy today, so I tried to cover as much of that as I possibly could. Stay to the end for announcements. There are some changes coming up that I want you guys to be aware of. We've had to move our schedule around just a bit for this week. But in the meantime, take that deep cleansing breath, everybody. It's Sunday. You've made it. It's the end of the week or the beginning of the new one, depending on how you look at it. Hit that like button if you haven't already. Subscribe if you haven't already, and share this with anybody that you think might enjoy it. Should we jump right in? Who's going to kick us off this morning?
Hello, crew, Josh, Tiff, Kaylin, all you lovely folks that do all the good things. This is Ashley from Linwood, second time caller now. My question this time is about something you said in this past week's Sunday Fun Day about how judges are chosen for cases in California and that there's a top floor where all the big wigs are and they get the big, tough cases. And so my question then is, how did the Honorable Judge Ito get OJ? Because if we're going to talk about somebody who appeared to be in over his head and let the defense take over and run the show and put on quite a show, and in addition to that, wasn't his wife in conflict with Furman? Anyway, I feel like there were lots of problems with that choice. And if we're picking the best for such things, how did we wind up with that? Anyway, I know it's bringing up old history, but I guess I'm old enough to remember. Talk to you soon. Bye-bye.
Thank you so much, Ashley from Linwood, Washington. Let's put you on the map. Appreciate you calling in. I do remember your first question. Glad to see that you came back for more. O.J. Simpson and Judge Ito. Isn't it amazing? What are we, 30 years out now? More. And this still is a fascinating case. Still one of the more fascinating cases to me. And as far as the trial goes, I've watched, I feel like, every documentary about this thing, every dramatized series about this, and I still can't get enough. It's still a fascinating story because it's about, celebrity and LA politics and racism and attorneys and trials and a prosecutor who thought they had a stronger case than they did. And, you could go on and on and on. And, end of the day, many people think that this was one of the biggest miscarriages of justice ever. And so it's still something that we talk about. Well, how I spoke last week about how judges get appointed in Los Angeles, at least, because we were talking about the Tyler Robinson case out in Provo, and Judge Graff out there is a brand new judge. He had only been on the bench for a few weeks, I think it was, before he got assigned the Tyler Robinson case, one of the biggest cases, if not the biggest case in Utah. And I thought, you know what, this guy, I feel bad for him. A part of me is like, he got really thrown in the deep end as a brand new judge. In Los Angeles, it works far differently. First of all, when you first become a judge, you get sent out to like the minors. You go into some branch court somewhere, you know, out in you know, the far reaches of the county, and you're doing misdemeanors. You're doing DUIs. You're doing suspended license cases for perhaps a year or two. And then you slowly work yourself up to felonies. And then as you kind of distinguish yourself and other judges are watching, presiding judges of each branch court, the presiding judge of the entire county is watching and keeping notice and seeing how well you do and how you get through your caseload and what the feedback is from other judges and attorneys and DAs and defense attorneys. And eventually you build up a reputation and you start to work yourself towards the ultimate goal for most judges. A lot of judges are like, you know what? Send me to a courthouse that's close to my house, and that's all I got to do. And I'm just going to live out my life here. And I got nothing wrong with that either. But a lot of the kind of high flyers want to go to CCB. That is the criminal court building, downtown Los Angeles. That is the big building where all of the big trials that you've ever heard of are tried out of, including OJ. And then in CCB, you have the 9th floor. The 9th floor has, let me think if I can roughly estimate this in my head. I think it has 1, 2, 3, 4. It has 8 courtrooms, I think. That's it on the 9th floor. I think I'm getting that right. So 8 judges handling the most high profile and complex cases in the county. Not all of them. Some, well, most, one that distinguishes itself is the Menendez brothers. That was done in Van Nuys, not in CCB. But most of the high profile cases are going to go downtown CCB 9th floor. Why is that? Well, one, they've got the infrastructure to handle it. They've handled these high profile cases. They've got the security. They've got the manpower to handle it. And they've got the judges. The judges who are all down there are used to these really complex cases. And I'm not just talking about cases that involve celebrities and make the news. I'm talking about multi-defendant cases, death penalty cases, cases that involve incredible complexity, and you want a very experienced judge. And that's where they usually all end up. Not all of them, but most of them end up there. So the mere fact that Judge Ito made it down there tells you a lot about who he was before OJ. He was considered a very, very good judge, and he was. He had a very good reputation. He had been a DA for many years. He got appointed. I don't believe he ran. I believe he was. No, I am correct. He was appointed in 1987, and OJ doesn't take place until 95. So he had been a judge for close to 10 years before that, on top of all the time that he had been a DA. He was considered a very smart, good judge. When this case went to him, no one really thought to themselves, that's going to be a problem. What I think this demonstrates more than anything is these high profile cases can really change people. And when those cameras are turned on and the microphones are rolling, people start to act differently. And I've said this before, it changes the way attorneys act. It changes the way the judges act. It changes the way that I think jurors sometimes respond to all of this. And the OJ case is probably the best case study of any of that. Ito lost his mind. He really allowed the celebrity of the entire situation to get to him. I'm not the first person to have ever said this, but there are stories of him, you know, celebrities would come to watch the trial. They'd be given preferential seating inside the courtroom. He'd invite them back into chambers during breaks. Ridiculous kind of stuff. Stuff that were happening now, you would all be losing your brains. You'd be pulling your hair out going, what is this judge doing? And he was doing all of that. And it was just bizarro world during that time, how this case was being treated. And I'm not saying the results of this case fall at his feet, but a lot of it does. A lot of the decisions that he made, a lot of the time that he took, the sequestering of the jury through the entire process, a lot of it in retrospect, and even at the time, people are going, what the heck is this man doing? And, you know, I'm not trying to beat up on him now, what, 30 years later? Am I doing that math right? Please don't tell me it's longer than 30. 30 years later, I'm not trying to beat up on him any more than he's already been beat up on. But I think if he even himself had to do it all over again, he probably would have done it differently. The story about his wife, I think, has been blown a little bit out of proportion. His wife was a sergeant in the LAPD. Her name was Peggy York. She had at one point, in a supervisory capacity, I think Mark Furman had gone through her station or something like that. But the idea that he should have recused himself based merely on that association, I think, is a little bit overblown. It wasn't like she had like inside knowledge of Mark Furman or how he behaved or anything like that. Anyhow, yeah, thank you, Ashley from Linwood, for giving us an opportunity to revisit that case once again and throw a couple of jabs at our poor buddy, Judge Ito, one more time. Deb, thank you so much for supporting the mods with coffees. Appreciate that. And Shy Gal, thank you, says that's where ASAP Rocky and Monica Cementelli were tried. That is correct. All on the 9th floor. Danny Masterson, Harvey Weinstein, Phil Spector. It goes on and on and on and on. You can think of, I'm trying to think of other cases, but every pretty much huge major case you can think of. David right now is going to be on the 9th floor. What else? All of those stuff. Like I said, every once in a while, you'll get a case that might go out to Van Nuys or to Compton or something like that. But for the most part, they're getting sent downtown. All right. Thank you. Nick Reiner. Yeah. Thank you, Tiffany. Nick Reiner from the backstage. She shouted out Nick Reiner. That's true too. Court Dog Daniel, thank you so much for supporting the mods with coffees. All right. And thank you, Ashley, for kicking us off this morning. Let's get to our next caller.
Hi.
Oh, hold on.
Good morning, Joshua, Tiff, Caitlin, ain't no hollaback girl. Josh, yesterday was the final pretrial hearing for Lindsay Clancy. Judge Sullivan has denied her defense team's motion to allow witnesses to testify in the trial next week who have experienced postpartum psychosis. His reasoning was that they had no link to this case and that they chose, when having these thoughts, to look the other way, drive the other way, walk the other way, and did not entertain committing suicide or unaliving their children. And further stated that if he allowed such a motion, that the prosecution would then have to introduce more witnesses and the trial would become a trial within the trial. Very complicated. And she is not saying that she did not unalive her children. She is saying that she's guilty, but she's not claiming responsibility for her actions. I just wanted to remind everyone that those 3 little babies were unconscious when the EMTs arrived. The 5 and 3-year-old daughter and son passed away that evening, and little baby Kaylin, who was only 8 months old, did survive for another 2 days. Just such a tragic story. And I've now read that Patrick has since remarried, but stays an active party in the ongoing civil suit, claiming that the doctors over-medicated his ex-wife. So your thoughts on this?
Ain't no hollaback girl from Kawartha, Ontario, Canada. Let's put you on the map. Good to hear from you again. A lot of questions, like I said, about Lindsay Clancy today. And so I tried to take a sampling of at least the topics that you guys were most concerned with. And this is one of them that comes up again and again. Obviously, the idea about postpartum psychosis. And in particular, this ruling. The ruling by the judge to not allow other witnesses to testify about their experiences with postpartum psychosis, depression, whatever issues are attendant to that. And I had said before that I think the judge got this right. And some people I know are saying, well, no, that's not fair. You need to have a real understanding of what this woman was going through. Yes, you do. And that will be her defense attorney's job. And they have hired experts to do exactly that. But bringing in anecdotal evidence of other people who may have suffered from the same sort of mental distress and asking them to explain to jurors what that's like really doesn't have a place in a criminal court. Think about it in a different situation. Okay. What if you had a person who part of their defense was some other type of mental disorder, schizophrenia, or perhaps they were saying that they were intoxicated, or perhaps that they were saying that they were overly tired. We're not going to start bringing in folks who can explain what it's like to have a few cocktails, or explain what it's like to not get enough sleep, or explain even what it's like to suffer from bipolar or schizophrenia. Their individual experiences is irrelevant to the experience of the defendant. Now, where it can become relevant is through the experts. The experts can say, I have treated many people with this disorder. I have treated dozens of people who suffer from extreme postpartum psychosis, and the consistent symptoms I see are X, Y, and Z. And the consistent ways that that manifests itself is X, Y, and Z. And the way that I know that she was suffering from that in this instance is X, Y, and Z. And they may even be able to make the final opinion that I believe that she could not understand or appreciate the consequences of her actions because of X, Y, Z. That might become a point of contention, because that is the ultimate issue that the jurors will need to decide. So I could see the prosecution objecting to that, but those experts will be able to testify to that, and they'll be able to say that they've done that based upon their research, their education, case studies, and their own patients. But for them to start even individualizing per patient is not what a criminal court is for when we're trying to decide what was the defendant going through. And ANHBG makes a great point, because how is the prosecution supposed to rebut that? Do they then call everybody who also suffered from postpartum psychosis to say, hey, I suffered from this, but I didn't do X, Y, and Z, and I didn't feel X, Y, and Z, and I certainly didn't do anything as horrible as take the lives of my children? You can see how unfair that would be to her as a defendant for the prosecution to do that. And that's why the judge didn't allow it in this case. It really isn't that outrageous of a decision when you start to break it down that way. They will certainly get an opportunity to explain to jurors what that is and how a person who has that and it's been diagnosed and treated for that will behave, and how that might affect their ability to appreciate what's happening. Remember, we're going to talk about this more than once today. This question is not a question of was she sick. If this were a trial about was Lindsay Clancy sick, the trial would be over in my view. She was sick. Even from everything we've heard, she was just under the prescription of a dozen different medications, highly, psychotropic type medications, had been in and out of treatment, had been with doctors, all of this. Clearly, I think she can establish that. The question, though, is not did she suffer from all of that, but in suffering from all of that, did she not know what she was doing was wrong? That's a very, very narrow question. That's a very specific question. And that question doesn't exclude mental illness, doesn't exclude planning, doesn't exclude premeditation. But just did she know what she was doing was wrong? We'll get into it more later, so I don't want to talk too much about it right now. But thank you so much, Hollaback Girl, for asking that question. I really appreciate it. All right, let's keep it rolling here.
Hi, everyone. This is Witske. I'm calling from Urania in South Africa. I'm a first-time caller, so I'm a bit nervous, but I have a question. Is the purpose of a prelim and a grand jury the same? I would like an answer on that. Thank you. I've been wondering about that. Thank you so much and have a nice day.
Witska from Orania, South Africa. Let's put you on the map. I love it. You got a couple of other friends down there. You might need to take a little bit of a road trip, but you got some other friends around you. Thank you so much for being a first-time caller, too. Don't be nervous. I thought that was a great question, and we appreciate you joining the conversation. Witska wants to know, is a prelim and grand jury accomplish the same thing? And the answer is yes, they do. Are they for the same purpose? I should say generally yes. A prelim, what this all comes down to is two constitutional amendments, okay? The Fourth and the Fifth Amendment. The Fourth Amendment guarantees probable cause, and the Fifth Amendment guarantees no person shall be held for a felony without a grand jury indictment. I'm obviously paraphrasing. But what we, after years, 250 years now, of common law and analyzing these amendments and Supreme Court decisions have decided is that what that means is that if you're going to arrest somebody, we're not going to let you hold that person in custody or under bail without some impartial party making a determination that there's probable cause to keep you in custody or keep you under bail until you go to trial, because trials don't happen immediately. So if we're going to do that, there needs to be some sort of probable cause determination, not a determination of guilt beyond a reasonable doubt, but a lower standard of probable cause. It's a test. It's a, what do they call it? It's a stress test. We need to stress test the prosecution's case. So you go in front of a magistrate or judge, and you present to them some of your evidence, not all of your evidence. You can do it in a more streamlined fashion. Some of the evidence rules don't apply. And the judge makes a determination that, yes, there's probable cause to hold this person to answer. That's called a preliminary hearing. Or in some jurisdictions, they put it in front of a grand jury, a jury of, sometimes it's as many as 30, sometimes it's as little as 18. You put it in front of those people, present that same evidence, and you ask them, do you believe there's probable cause that this person should go to trial? And they say yes, and then they return an indictment. So it accomplishes the same thing. Now, the grand jury can also serve other purposes. It can answer different questions, but a lot of times, and in a grand jury being asked to indict, they're doing the same function that a judge would do. And it's really up to the jurisdiction. I was talking to a friend from New York. In New York, they do everything by grand jury, which is so strange to me because it seems like such a cumbersome process to have everybody, all these people sitting there and hearing case after case. In California, we do most of things by prelim. You put it in front of a judge, and that's what's happening with the David case right now. You put your evidence in front of a judge, but many other cases go much faster than that. I mean, I've handled prelims that lasted 20 minutes long. In fact, at one point when you're in the DA's office, you have a prelim assignment where you're doing nothing but prelims all day long. And we would have contests to see how quickly we could get a prelim done. Like how few questions could we get a prelim done? Officer, please tell me, what is your background, training, and experience, and where were you on the date of January 12th, 2026? And what did you witness at that date? And is that person in court? Thank you, I rest, Your Honor. Like, it was like kind of that quick sort of stuff. But obviously with the more complex cases like David, it's already taking now. We're going on to day 5 on Monday. Anyhow, thank you, Witska. Hope that answers your question. It's all about that stress test of the people's evidence to make sure that we're not holding people in custody who we just don't have any evidence against. Thank you so much. All right. Sleuthy Sweetheart, thank you so much for the super sticker. That's very kind of you. Jenkelmans, thank you so much for am I saying that right? That's how I would say it. No? Janselmans? How would you guys say it? Don't give me those looks. Thank you for gifting the membership. I appreciate you. And Allie Foley says, my niece loves my CC tan lines and timelines towel. Oh, I love that. Jan Clemens, go back there. Oh, I see now. Jan Clemens. All right. Well, thank you, Jan. All right, let's keep it rolling before I embarrass myself anymore.
Hi, Josh and CC community. This is Fluffy Nettie from Wasilla, Alaska. That's Fluffy with a PH. I have 2 questions today. My first question is not case specific. When a jury is impaneled to determine sentencing, does their decision need to be unanimous as it would need to be in the guilt phase? Or is there a range of penalties or a lesser sentence that can be reached if the jury can't agree on the penalty? And my second question is more case specific. Can you advise me on pressing stalking charges against this pesky rain cloud that follows me everywhere I go? 90% juiced. Get rid of this rain cloud and I will be 900% juiced. That's it. Happy Sunday Fun Day, everybody.
Fluffy, I'm doing a lot here. I'm doing my best. Controlling the weather, I don't think is in my strengths. From Wasilla, Alaska, I would have said Wasilla, so it shows you again how wrong I am on that. From Wasilla, Alaska. We've had a caller from Alaska before. Was this Fluffy again? I love it. See that? You're holding down strong. Got her. Now we've got all 50 states. Wait a second. What is going on with the Dakotas? What is going on? We got to do like an advertising campaign just for, is that North and South Dakota? We've never had a caller from there. We got to do some sort of advertising campaign. That's so funny. Well, we'll get there eventually. Thank you so much, Fluffy, at least for taking Alaska off of our checklist. So Fluffy wants to know, does sentencing have to be unanimous? Does a sentencing verdict need to be unanimous? The answer, especially when it comes to all things sentencing, is it depends on the jurisdiction. It varies wildly. Very strange. Most jurisdictions, you're going to have the same crimes, right? You know, certain crimes are always going to be on the book in every jurisdiction. But how they punish those can vary wildly. And the answer is not always. In some jurisdictions, yes, it has to be unanimous. In some jurisdictions, the jury doesn't have a verdict on sentencing. In California, where I'm used to, the jury never has a say on verdict unless it's a death penalty case. That's the only time that they ever come in and make any kind of determination on verdict, is if we're going to ask for death or life without parole. And in fact, in most of those cases, when they're not pursuing death, their job is done when the case is over. But in some jurisdictions, they have to go back and then decide sentencing. In some jurisdictions, they come up with a number. We just saw the Carmelo Anthony case out of Texas. The jury was the one who came back with 35 years on that. There were recommendations from both parties, but they're the ones that came up with the number. I've seen it in almost every combination that you can think of. I've seen it where the jury has guidelines. I've seen it where the jury doesn't have guidelines. I've seen it where the jury is given a choice of different numbers to pick from as far as years. I've seen it where the judge can overrule it, where the judge just takes it as a recommendation. It's really all over the map. And even the ranges. I mean, I think it was Utah that they have, like, for certain crimes, it's like 3 to 90 years or something like that. Again, I know I compare a lot of things to California, but that's just what I'm used to. So I'll give you kind of another example. Most things come in like a triplicate: low end, midterm, high term. So you'll have, for let's say a robbery, it will be 2, 3, 5, 2 years, 3 years, 5 years. And the judge will pick, oh, this is a first-time crime with no aggravating circumstances. I'm going to give them low term. Or this is a second-time crime and there are aggravating circumstances. I'll give them high term. But those are what they're choosing from, and they're not going off of anything. They're not choosing wildly from, whatever comes into their head. Another example is Florida. At most, I will say the standard is you have to have a unanimous verdict from jurors when it comes to the death penalty. If you come up short on all jurors voting for the death penalty, the default is life without parole, except in Florida. You remember the Nicholas Cruz case. This was in 2023, 2-3 years ago. That was just a penalty-only case for the horrific shooting at the school in Florida. Oh my God. They came back 9-3 for death, and people were really upset with this. They thought if there's anybody deserving of death, it was this case, and they changed the law. Now in Florida, an 8-4 vote for death will get somebody the death penalty. So it's up to each jurisdiction and how they want to put the laws on their books. Thank you so much, Fluffy. I know that doesn't really answer your question, but hopefully it gives you a better understanding of how it all works. From Wasilla, Alaska. Annalie Finch, thank you so much. Says our CC crew asks the best questions. They do. They ask the best questions because they're the smartest community on YouTube. Thank you so much. Race and Rodeo, Charlie Anderson should be watching from North Dakota. Okay, sounds good. And Ida Van Schalkwick. Yeah, I think I got that right. Says, don't worry about the pronunciation. From South Africa originally. Thank you very much. Appreciate that. All right. Isn't it cool what an international community this is too? Like Adelson, North Dakota, Charlie. Oh, Adelson. I said, what did I say? Anderson? Charlie Adelson should be watching from North Dakota. Oh, yeah. Is that where he's housed now? They shipped him way up there? Oh, that's funny. Does he have internet access? I missed the joke. I'm sorry about that. What was I saying? Oh, we got an international community. I just think that's very cool. I just think it's kind of amazing that sitting here in my little storage room in front of my computer talking to myself alone, and you can hear it all over the world. Pretty incredible stuff. Pretty scary too, to think that I have that kind of access. Anyhow, let's keep it rolling here.
Hi, Josh. This is the bipolar astrophotographer. My name is Kara, and I'm in Colorado Springs. I'm a first-time caller, but a long-time listener. I just finished watching your Wednesday night stream regarding Lindsay Clancy. As someone who has struggled with bipolar disorder and on one terrible occasion, psychosis, this case draws heavily on my empathies. You talked about the difference between insanity versus criminal insanity, with the main question being, did she know that what she was doing was wrong or a crime at the time of the murders? I keep thinking about the quote by Carl Jung. The pendulum of the mind oscillates between sense and nonsense, not between right and wrong. Isn't nonsensical thinking a symptom of psychosis? Couldn't not caring about the consequences be delusional thinking as well? If in an altered state of mind you think up is down and down is up, isn't that more nonsensical than morally wrong? I'm also having a hard time understanding that for one to qualify as criminally insane, that they are no longer able to think altogether or plan ahead of a crime. Psychotic behavior doesn't take away your abilities to think or plan, it perverts them. My question to you is this: can you give one or more examples where someone was found not guilty by reason of insanity, where you truly believed that they didn't know that what they were doing was criminal or illegal in the midst of their delusional crime? For me, any adult human being on earth in 2026 couldn't not know, regardless of their mental state, that murder is a crime. Anyway, thanks for answering my question. Happy Sunday Fun Day, everyone. Bye.
Thank you so much, Kara from Colorado Springs, Colorado. I almost want to listen to that again because you bring up so many great examples, and you're talking a lot about psychosis. And you're absolutely right. Psychosis doesn't necessarily mean the inability to plan. But in your explanation lies the problem that I think a lot of people have with understanding this, because psychosis is different from insanity in a criminal context. We did ourselves, the more I think about this, the more I feel like we did ourselves a disservice in the law by ever calling this insanity to begin with, because it really starts to bring up medical and psychiatric questions and analysis when it really isn't. They use insanity as a placeholder, as shorthand for what they really mean is mental illness that causes an inability to appreciate the consequences of your actions. The law is concerned with two things, right? Mens rea and the actus reus. That you did the thing, the act, and the way you thought about it was in a criminal way. Okay, so usually the act is not a problem. The act is murder. The act is killing someone. The act is shooting a gun. The act is stabbing someone, whatever that is. But then we really concern ourselves with what were you thinking about the time? Think about it. The difference between manslaughter, second-degree murder, first-degree murder, all of those have very little to do with the act. You can stab someone, you can shoot someone, and it be a voluntary manslaughter, involuntary manslaughter, second-degree murder, or murder. You have no idea just based upon the act. You have to know what that person was thinking. And if that person did it on accident, or did it in the heat of passion, or did it because they were angry but thought about it for a moment, or because they had planned it for weeks, those can change the degree and change how long we put that person in prison. You can stab someone to death and get probation, but if you thought about it and planned it differently, you can stab someone to death and get the death penalty, because we're very concerned about what's going through your head. So when it comes to the law's concern with mental illness, it's not about psychosis and psychotropics and what people think and delusions and everything else. We just want to know, did you know what you were doing was wrong? Did you know you were doing a wrong thing? Even if you don't care about it, do you know what you were doing was wrong? That's part of Kara's question, is what if she didn't care about the consequences? We don't care. When I say we, I mean the law doesn't care if she cared about the consequences. The law just wants to know, did you know it was wrong? That's the very, very, very specific question that's being asked. And it's hard for us sometimes to understand that. You asked me to give you an example, and I've been thinking long and hard about this. There was a case out of Los Angeles here back in 2022 by a woman by the name of Nicole Linton. You may have remembered this case or maybe not. She was a traveling nurse. She had a very good record. No prior arrests, no signs of any kind of violence or anything like that. And August 4th, 2022, she drives her Mercedes at 130 miles per hour through a red light and T-bones a car with 6 people inside of it, killing all 6 of them. 5 people, one of them being pregnant. So she kills everybody inside of the car, including the pregnant woman. She's charged with 6 counts of murder. It is horrific. She's charged with murder. Her defense is saying she had been suffering from some perhaps diagnosed, but also some undiagnosed mental issues, including perhaps bipolar disorder, episodes of paranoia and delusions and hallucinations. Okay. And she has, according through her attorneys, no memory of what took place. They are arguing that she entered some sort of delusional dream state where she didn't even know what she was doing. When we talk about insanity, that's what we're talking about. A person who literally doesn't know they're driving, doesn't know they're pressing the gas, doesn't know any of what they're doing. They have zero control either over their own body or over their own thinking, and they don't know what they're doing is wrong. I asked a friend of mine who's a prosecutor to give an example, and he said it's when you strangle a tomato to death and later on realize that was a human being. It's not knowing in the moment the thing that is happening is a wrong thing. So bringing that back to Lindsay Clancy, that's going to be the question. That's why the prosecutors are so concentrated on the steps that she took, on the phone call to her husband, on the sending him on an errand, on a realizing how long it would take him, on the process of strangling each of the children, on even the steps she took afterwards. All of that, because they're trying to say, listen, this is not a person who was so untethered from reality that they didn't even know what they were doing, and they didn't know what they were doing was wrong. This is a person who may have been incredibly troubled by their mental illness, that they did a horrible thing, but we have circumstantial evidence that they knew that horrible thing was a thing they didn't want their husband to stop them from doing. And why was that? Because they knew that was wrong. I don't know which is the winning argument here. And again, I think we do ourselves a favor to wait until we see how a lot of this evidence plays out. And this is a case that I do not envy the jurors on this one at all. It is a very difficult question. You've got a woman who has no signs of any kind of violence, no signs of any kind of ill feelings towards her children, sounds like she was an incredible mother, and does a horrific, nightmarish thing that she will never, ever heal from. She was obviously suffering from mental illness. She may have been overprescribed, underprescribed medications, all of that stuff. And then on the other side of it, you have 3 babies who died probably a terrifying death at the hands of their own mother. What do you do with that? I do not know how these jurors are going to get through this whole thing. It is not going to be easy, but I hope that explains a little bit more what we're talking about, Kara. Great question. I appreciate you calling in for the first time again, and sharing your experience with us, and for asking that question. I know a lot of people have been wondering very similar things. All right, let's keep it rolling here.
Hi, Josh, Tiff, Caitlin, CC, crew, and the lovely mods. It's Little Miss Red Velvet from Manchester. Well, I'm still in one piece, just about. We're out of the World Cup, so I can actually relax and settle down and send in a question for Sunday Funday. It's around Tyler Robinson and the key witness, Lance Twiggs. I just want to ask about the fact that he does have an immunity, but could you tell us a little bit about the fact that if they wanted to bring some new charges, I wanted to ask about co-conspirator versus accessory after the fact. Could you explain the difference between both of those, Josh? And do you think in this case that it could happen? Look forward to seeing you all on Sunday. Take care, everybody. Bye.
LMRB from Manchester, England. So good to hear from you. Always brighten my day. Lance Twiggs, Tyler Robinson. Lance Twiggs was Tyler Robinson's roommate, romantic partner, and now his star witness against him in his prelim and his upcoming murder trial for the murder of Charlie Kirk. He's been granted use immunity, use derivative immunity, whatever you want to call it. What it means in its simplest term is, we want to talk to you. Well, I got nothing to say, and I've got a Fifth Amendment right, because you guys think I did something wrong, and you're investigating my friend and probably me. Good point. We're going to grant you immunity. You don't want to talk to us. We're going to make you talk to us. We're going to compel you to talk to us. This is not cooperative. This is compelled testimony. And the only way we're getting you to do that is we're granting you immunity. By the way, Lance Twiggs didn't ask for immunity. He was handed immunity. And then they said, now you need to sit down and talk with us. So he sits down and speaks with them. And everything that he says to them, because of that grant of immunity, they cannot use against him. We're going to get, I think there's another question on this later, so I don't want to talk too much about immunity. But if they decide that Lance Twiggs wasn't entirely honest with them, or they find out that he was far more involved later on through other mechanisms, they can prosecute him. So what would they prosecute him with? Well, it would really depend on how much he was involved and when he was involved. If they're looking for a co-conspirator avenue of culpability, liability, criminal liability, they would be looking at, what did he know ahead of time? How much was he involved in the planning? He doesn't need to know everything. He doesn't need to know the entire plan, but did he somehow further the conspiracy in some small way? Did he play some part in that? And that would create some level of criminal liability for him. Or if he was not involved at all, but after the fact, he disposed of some evidence, hid some evidence, lied about some things, that could be considered an accessory after the fact. It really depends on what he knew when he knew it, is what it'll come down to as far as whether or not they would ever prosecute him. My answer to you, though, Little Miss Red Velvet, is I don't think they're ever going to prosecute him unless they discover something, that it was in fact Lance Twiggs that was the mastermind in this whole thing, and Tyler Robinson was just his patsy. If things remain how they are right now, I think the state is very comfortable with Lance Twiggs remaining their star witness and Charlie Kirk remaining their defendant. So I think that's how things will continue. But great question. LMRV from Manchester, England. All right, let's keep it rolling here. I got to kind of keep things on a tight ship today because we got to get out right at the 2-hour mark. All right.
Hi, Joshua. It's Jim from the Marshall Islands. I was just wondering, like everyone I'm sure that's listening, I watch a lot of true crime. And something that has always bothered me about U.S. law enforcement is that they're allowed to lie to suspects. I mean, I think just on its face, that is just so fundamentally unfair. And I know it's from a Supreme Court decision that they decided that that's okay. But, after doing a little research, we're really the only advanced democracy in the world that allows this. And it just seems like, especially when you're dealing with young people, the cognitively impaired, people who are confused, 15-hour interrogations, we have your blood, we have your semen, we have your DNA. I just feel like it just seems so on its face wrong. And unjust. I mean, otherwise, I think our law enforcement system is actually very good and very admirable. But I just feel like that's one thing that we're really a world outlier among, advanced democracies. I just wonder what you think about it. Thanks.
My friend Jim from the Marshall Islands, one of my dudes. I love this. I want to know who else has got listeners from the Marshall Islands. How cool is that? Hope you're doing well, my friend. Great question. What are your thoughts on investigators being allowed to lie to suspects? I get where you're coming from. Absolutely. It does seem unfair. It does seem like, you've got the power of the government and they're coming down on somebody, and with all of the other advantages that the government has, that they're now allowed to lie on top of it. I get it. I think another way to look at it, though, is that much of our laws, when it comes to criminal procedure and constitutional law, are designed to protect the individual from the government, including laws surrounding this. Now, yes, it is true. There's a long line of constitutional law that says you you are allowed to use subterfuge, is the way they put it, in interrogations. But that is not a full stop permission. Unfettered permission is what I should have said. It is judged in a totality of the circumstances. And believe me, every time this comes up, there's a lot of litigation following it about whether or not that confession was coerced is the ultimate question. Was it involuntary? Was it coerced? So they can say stuff like that they have evidence that doesn't exist, that they have witnesses that don't exist, DNA that doesn't exist, videotape that exists. The Supreme Court views this as if a person is not implicated at all, then bringing these things up shouldn't cause a person to confess to something that they didn't do. And you might say, well, listen, there are people who are easily influenced. You referenced the young, the cognitively impaired. Well, there are rules on that. And in fact, lying to juveniles or the cognitively impaired is highly suspect, is something that the courts oftentimes throw out. There is Supreme Court decisions and a line of cases talking about specifically that, dealing with the cognitively impaired, dealing with juveniles and interrogations. And it's not just about lying to them. It's about a whole bunch of other stuff in interrogations. They're treated entirely differently. But yes, it does come down to a totality of the circumstances evaluation. And sometimes it doesn't even need to be lying, right? That could be the stuff that is harmful. It could be the waiting, keeping somebody in an interrogation room for hours with no food, and they're uncomfortable. And all sorts of other highly coercive techniques that are continuing to be scrutinized and continuing to have cases that we still have cases that go in front of the Supreme Court that have to do with confessions in particular. But one thing that they have stood strong on is this idea of the use of subterfuge. You asked me, how do I feel about it? I don't know. It's hard because there are many cases that get solved that way and righteously solved, not just a false confession, but a confession that it is absolutely the person, and they may not have confessed to it if the investigators had not got a little creative with it. So I don't know. I guess it comes down to what do you want to do? Do you want to get bad guys off the street and solve crimes, or are you willing to sacrifice a lot of that if it means that you never have an instance where people are lied to? I don't know. Difficult question. I don't even know if there's a right answer, but I appreciate you encouraging the conversation. Jim, my friend from the Marshall Islands. All right, let's keep it rolling here. Where are we off to next?
Hello, CC crew. My name is Krina, calling in from Nampa, Idaho. I am a first-time caller. Josh, earlier this week, you were talking about expert witnesses and their CV. What is a CV? Looking forward to hearing about this on Sunday Funday. Juiced!
Krina, first-time caller from Nampa. Not Nampa, but Nampa, Idaho. Let's put you on the map. Could you zoom out there for a second? Where is Nampa? Wait, keep going. Where are we? What? I can't even see the lines. Oh, it's okay, Kaylin. Just I'll deal with my... Oh, way up there. Oh, no, it's near Boise. Is that right? Oh, okay. Near Boise. All right. Well, thank you, Krina. What is a CV? A CV is what fancy people call a resume. That's all it is. A CV is a resume. It's called a curriculum vitae. Whenever you're using Latin, you know that you're trying to be fancy. Whenever you use Latin, you drink your tea with your pinky sticking out. It's just kind of a general rule. It is the resume of what experts use. People who are, it's more than a resume. It's a entire educational and expertise kind of log of a person. So when an expert testifies, you hand over their CV. That'll include everywhere they went to school, everywhere that they've taught, every paper that they've ever written, research project that they've ever been a part of, perhaps even every place they've ever, every book that they've ever written, and maybe even speaking engagements that they've made. And these things can go on for pages and pages and pages. The reason they're important is, one, to establish the expertise of that person, but also to give the other side an opportunity to research that person to perhaps impeach them. A really good attorney will take that person's CV and get every single one of their prior papers that they've ever written, every one of their scholarly works that they've ever had, every piece of writing they've ever put out there, and get it all and research it. And if they say something different on the stand than what they may have said in a published paper of them, then you've got a great piece of impeachment for them. But that's what it is. It's when you get into the world of academia and you start publishing papers and academic research projects and everything else, you start to collect yourself a CV. I myself do not have a CV. I have a resume, and it's not all that impressive. So thank you, Karina from Nampa, for calling in with that. I appreciate that. All right. Not my fault, Kaylin.
Hi, Courtroom Confidential crew. It's Sue calling from New Zealand, long-time listener, third-time caller. I've been watching the Blaise Taylor trial with Gisela. In fact, she calls him Blaise Truffle Boy Taylor. And I think it is that he comes from quite a well-to-do, nice family. He had a good job. He's sort of on the outside world, was quite well educated. He had his own non-profit that he'd set up. So from the outside world, he sort of had a sort of nice life before he committed this atrocious murder. He's no Adam Montgomery. So I just wondered, despite the best efforts of his defence lawyer, who I actually think was really good, he's now facing a very long, lengthy prison sentence. And I just wondered, when in the process would you start talking to your client about the possibility of prison and getting them ready for the, psychologically, I guess, for the thought of going to prison, what it's going to be like, how it's going to be different. It seems like for someone out on bond, it's a huge, huge adjustment. I mean, it would be for anybody, unless you're Adam Montgomery. So I just wondered how that process works. And also, Joshua, we need to start having some merch for your Southern Hemisphere callers who need Adabai's melt in the snow, because it's freezing here in New Zealand in winter. Yeah. So if you could start working on that merch, that would be great.
Sue from New Zealand, are you telling us we forgot about a whole half of the world with our summer merch launch? I think we still have some hoodies and sweatshirts up there on the shop, but great point. We need to not forget about all of our Southern Hemisphere crew members. Sue from New Zealand, great question. Talking about the Blaise Taylor. Well, you referenced the Blaise Taylor case, and I'm glad that you were watching that with Gisela. She's fantastic. We're huge fans of hers and grisly true crime. And I'm only saying that so I can see the chat fill up with teddy bears. But we're huge fans of hers, and she's a big supporter of ours, and so we're very appreciative of her. You referenced this, but I think your real question is just in general, as a defense attorney, when in the process do you start warming your client up to there's the teddy bears. There they go. When do you start warming them up to the idea that prison may be in their future? This is such a great question. the first half of my career I spent in the DA's office. And when you're a prosecutor, you don't really deal with people. I know that sounds weird, but for the most part, you're dealing with witnesses and you're prosecuting a person, but like your interaction with people isn't nearly as much as you might think. Yes, victims are a huge part of that. And that is something that takes a certain level of bedside care that a lot of prosecutors are not great at. I wasn't great at when I first started. And then I began to realize very quickly how important it is to appreciate victims and what they're going through, and that they're not just your witness, they're a victim to a crime. And then, once you get into murders and things like that, and you're dealing with family members who've lost loved ones, you really start to understand that. But when you become a defense attorney, your whole career comes with dealing with this one person. And you're not just their lawyer, you're their therapist, you're their bartender, you're their person that they call when they're in trouble. I get calls from clients all the time that they just need a little comfort. Sometimes you're the only person in the world they can turn to in this time of distress. Sometimes you're the only person in the world that knows what they did. And you take on a lot of different roles and wear a lot of different hats when dealing with some clients. And one of the things you got to get good at is getting people warmed up to the idea of where this all might be headed. Now, I have always felt that it is not my job to oversell a client on their possibilities. It is not my job to talk tough and we're going to take this to trial and that prosecutor's a liar and their case is full of crap. We're going to win this thing. A lot of defense attorneys act that way, and they get a lot of clients for that. Pardon me, but I feel like they're tap dancing their clients all the way to prison. I take a real responsibility for the idea that the decisions I make are not affecting my life. They're affecting my client's life. And if we go to trial, I'm not the one who's taking the chance. I can do the best thing I can for them during trial. And at the end of the day, when that verdict comes in and it's guilty, I'm not the one getting handcuffs slapped on me. They are. So I feel like they are not entitled to, but deserve my absolute honesty about what I think their chances are from the very beginning. And many of them don't like it. I'll be honest with you. I've been fired over it. I've been fired over me being too honest with people. Me saying, this is not a good case. You do not have a defense here. We can take this to trial. I say it all the time. I'm not afraid of trial. I'm happy to take this to trial. We can do that all day long, but you do not have a good case. And I have to tell you that going in. And so the same thing goes with when they start to hear the idea of where is this headed. Many of them do not take it well. I remember a young man I had a conversation with, and we got an offer from the prosecutor, and it was a great offer. I ran it by several of my colleagues, and they said, you got to take that in a heartbeat. And it was 14 years prison. And I told him this, and he lost his mind. Fired me a week later, hired somebody else. They're headed toward trial. He's probably going to spend the better half of his life in prison. But I'm not going to sell these people short. It's a difficult conversation. And you have to understand the psychology of many people who get themselves into this kind of trouble to begin with. They've kind of been living on the edge for a while. This isn't like for the most part, it's not usually a anomaly in that person's life. They've been kind of living devil may care sort of a lifestyle for a long time. And now things have caught up with them and they think they're going to get out of it one more time. They just need that one more shot, that one more chance to get out of this. And when they realize the walls are closing in and this is it, they've had that last shot and it was the last one, not this one. it's a real difficult conversation. Some people take it standing up and others not so much. But great question, Sue. It's a hard part of the job. It's not an easy job. All right, let's keep it rolling here. Let me just get myself lined up.
Hey, Josh. Hey, CC fam. This is Bluebird 711 from Waddy, Kentucky. My question tonight just involves some thinking I was doing while listening to Cyray's last interview. He points out all the evidence that we know and just how risky, presenting the IGG before the court and their decision on that could have made or broken this case. There were lots of various anomalies and skipped steps, etc., that the state did make, which is one of the reasons that I think they also went for the plea. Considering this and considering the fact that that could easily be overturned in the future, depending on who's in charge, I was curious as to why the state did not insist on allocution. But would demanding allocution break a person's right to remain silent, therefore leaving another ground for appeal? Just a thought.
Bluebird from Waddy, Kentucky. Let's put you on the map. Appreciate you calling in again. Always nice to hear from you. We're referencing the Bryan Kohberger case here. Again, the idea that he didn't give any kind of statement. He didn't give any kind of allocution. The question is requiring an allocution abusive of the defendant's Fifth Amendment rights? Great question. I've said it before. I'll say it again. Smartest community on YouTube. I want you to ask this question to any one of your friends who don't follow our channel or are into true crime on YouTube or wherever else, and just watch their eyes go cross-eyed on you when you ask a question like this. Is requiring allocution abusive of the defendant's Fifth Amendment rights? So, no. First of all, no. When you take a plea, you waive your Fifth Amendment rights. If you remember, when Bryan Kohberger took his plea, we had the plea first and then the sentencing. The plea took half a day because the judge advises him of all of these rights that he has, including a right to remain silent, including a right not to implicate himself. And he has to waive all of those rights. By necessity, you are pleading guilty to something. So you by necessity need to waive your Fifth Amendment right, your right to self-incrimination, in order to enter into a plea. Sometimes prosecutors will offer a plea, but they want what's called a factual basis plea, meaning I don't just want you to plead guilty. I want you to plead guilty and admit certain facts. That can be required. Now, the defendant can turn it down and say, I'm not doing that. But you can require that. So it's not abusive of a Fifth Amendment right because you're going to ask them to waive those rights anyways and give up those rights. But we do know that there are instances where a person might want to enter a plea and not admit guilt because they just might feel it's in their best interest to do so. There's a couple of different ways that that's done. In California, you may have heard of a People versus West plea. This is where you're saying you feel it's in your best interest to do so, but you're not expressly maintaining your innocence. You're saying, hey, I'm not going to get into whether or not I'm guilty or not guilty. In fact, I'm going to plead no contest. And I'm going to do this pursuant to People v. West, meaning I know how bad things could get for me if I took this to trial. So given what the people are willing to offer me, I'm going to go ahead and accept that. But I'm not expressly denying or accepting, or I'm not necessarily waiving or maintaining my innocence. I'm just entering a plea. We've also heard of Alford pleas. kind of the same concept, but this is where you are maintaining your innocence. You're saying, I know you've got enough evidence that you would likely prevail at trial, but I'm saying I'm innocent here, but I'm willing to take a plea. This happens quite a bit. Not that we're putting a bunch of innocent people in prison, but people just say, I don't want to fight this because I know how bad things could get for me. And I'm not exactly saying I'm guilty of what you charged me with, but I know I'm guilty of something. And you're willing to offer me no prison, I'll go ahead and take that. I'll go ahead and take my chances, or not take my chances, and I'll go ahead and accept this plea. So we do have mechanisms for that, but it's up to the prosecutor to offer that or allow that, or the judge. But there are instances where prosecutors, I've done it myself, will say, hey, listen, I'm willing to not give you prison time or do whatever else, give you probation, but I want you to admit to stuff. I want you to plead guilty and admit to certain things on the record. So I hope that answers your question, Bluebird. The Fifth Amendment is already raised. All right. Let me thank some folks. Nana up 4, thank you so much, says, isn't her jumping out the window a sign of guilt? Obviously, we're talking about the Lindsay Clancy case here. You know what? I could see that going both ways, right? I think if you're the prosecution, you say, absolutely. A person who attempts to take their own life in that type of a way is a person who is reflecting on the profound nature of just how wrong what they just did was. If you're the defense, you might say, no, what this reflects is a person who is still in the heights of a psychotic break, and a person who still was under delusions or under having hallucinations and was being told to do all of this and didn't know any of it was wrong. She thought she was saving everyone. You could see them kind of arguing it both ways. It'll be interesting, though, to see how the defense tries to get that in, if that is in fact true, or if they just try to argue through their experts that that could be a sign of a person who's suffering from a psychotic break. Elizabeth, thank you so much for supporting the mods with coffees. You're so kind. Thank you, everybody. Tiffany, that's very nice of you. Thank you, Tiffany, for doing that. Thank you, everybody. If you're joining us today, I just want to welcome everybody who may have joined since I started the show. Thank you so much for being here. Please hit that like button if you haven't already. If you've been enjoying what you've been watching, subscribe if you haven't already. I feel like I don't let people know that enough. If you're sitting and watching and enjoying, we would love to have you be part of the community. And you may have noticed that this is also ad-free. So every time we do a live, we've made it a priority of ours to make sure that that's never interrupted by YouTube. And the way that we're able to do that is through all of your support. So we appreciate all the super chats and the gifts and all of that good stuff. You guys are fantastic, and we couldn't do this without you. All right, let's keep it rolling here. Now I lost my place. What did I just do? Oh, here we go.
Hi, Josh and CC crew. This is Mandy the Nerd from the San Francisco Bay Area here in California. I have a question about the Lindsay Clancy case, or more specifically, I guess, about the interplay between intent, premeditation, insanity, and kind of prosecution strategy, I guess. So I'm hearing a lot about how Lindsay appears to have planned the murders of her 3 children. You know, she researched a time-intensive path to get takeout from an unusual restaurant. She invented a need for over-the-counter medicine for one of the children. Basically, just made sure she had enough time to commit this awful, awful crime. So let's assume that's true, right? The prosecution convinces us all that yes, she planned it. 100% Lindsay formed an intent to kill, premeditated. But you've been teaching us a lot about this, Josh. I think legal insanity asks a completely different question, right? Did Lindsay, as a result of mental defect or injury, either 1, not understand the nature of what she was doing, or 2, not recognize the the wrongfulness of her actions, right? See, we've been listening, Josh. We've been listening the whole time. So I can see how premeditation, especially this kind of planning versus that, momentary choice to run the yellow light formation of intent, right? I could see how that could maybe prove that she knew what she was doing, right? It proves that she knew the act was one that her husband would stop her from doing if he knew about it, right? But if she's truly hearing voices and those voices are telling her to do things or else something worse will happen, and she truly believes that, she clearly doesn't recognize, planning or no, the wrongfulness of her actions. So what's the prosecution strategy here? There's a world in which they successfully prove it's premeditated, but that doesn't by itself prove she wasn't also insane. So they have to pair that up with other stuff, right? So what are those kinds of things? I think I just want to understand really what that strategy can be, given that those two things are not necessarily mutually exclusive. Okay, awesome. Thank you so much. Everybody have a great day. Bye.
Mandy from San Francisco, California. Let's put you on the map. What a great question, Mandy. What a great question. And you do an excellent job of really parsing out the complex issues involved in this whole thing. And you're absolutely right. Premeditation, planning are not mutually exclusive concepts to insanity. They're different. They're asking different questions. You're 100% right. Could she have planned this and premeditated it and still not appreciated what she was doing was wrong? Yes, absolutely. So what are they proving by proving the planning? Well, they have to prove they have to, through circumstantial evidence, prove her state of mind, right? That's all they've got to go on. All that they have to work on is circumstantial evidence of her state of mind. Well, if you're trying to prove whether or not somebody knew what they were doing, planning is a pretty good indicator of that, wouldn't you say? A person who doesn't know what they were doing, I think, might be more haphazard and chaotic in their actions, right? Not necessarily a radical concept to say. So the planning is important. The premeditation is important as far as circumstantial evidence of her state of mind and whether or not she knew what she was doing. And then the other question becomes, did she know what she was doing was wrong? You, and I wrote it down. You said, what if she did what she did because something worse could happen? Or it was kind of the idea of she was delusional or hallucinating about a bad thing happening if she didn't do what she did. Okay. Now that gives a understanding to the why she did what she did, to the motive behind it. But does that give us an understanding to the question of, did she still know what she was doing was wrong? In other words, could it still be true that she did what she did because she thought she was accomplishing some sort of greater good, but also knew what she was doing was wrong? There's, I think, reports that when her husband responded and found her outside, she asked about having an attorney. That is circumstantial evidence that she may have known what she had done was wrong, right? Now, you could say, well, that was after the psychotic break. And that's an argument that the prosecutors are going to have to make. But again, just because she may have believed God himself told her to do the thing, is there still evidence that she knew she would be arrested for doing the thing? Or that her husband would not want her to do the thing? That she would be arrested for killing her children, that her husband would stop her from killing her children, but God himself wanted her to kill her children? How does that answer the question? If the question is, did she know what she was doing was wrong or a crime? That's what it's going to come down to. You can have delusions. You can be untethered. You can be thinking that you're doing something for the greater good, thinking that you're doing something you don't even really care about. I think a prior caller asked about. But do you still know you're going to get arrested for it. Do you still know that it's a wrong thing to do? And that's why you had your husband leave the house. Great, great question, Mandy. These are the things that the jurors are going to be bringing back with them to the deliberation room. Oh, there you are. This is so helpful. Exactly what I needed to understand. Thank you. This is so helpful. Well, that makes me feel incredible because I thought that was an excellent question. And this is what helps us along in the conversation. Do you see why this deliberation is going to be so difficult? You imagine 12 of us all sitting back there and going through these incredibly dense topics. I pray for these folks. All right, I got to keep it moving because I'm running out of time. Pantufo says, why prosecutors are allowed to say in court that Lindsay Clancy wrote on whiteboard, do I need an attorney after waking up? Seems prejudicial or at least HIPAA violation. Oh, interesting. So is that what it was? She wrote it on a whiteboard. Do I need an attorney? Well, one, it's a statement from the defendant, so they're allowed to use that. It's not a HIPAA violation because it has nothing to do with her medical care. It has to do with her involvement in a potential crime. The only thing I would say is the do I need an attorney kind of already asking for legal advice? And I would say it would be a problem if she were speaking to an attorney at the time she asked the question. But if she's just asking law enforcement or attending nurses, do I need an attorney? That's certainly something that could perhaps come in. Yes, wrote it on a whiteboard in the hospital to a clinician. Very interesting. All right. Again, we'll see how this stuff all plays out, guys. It's going to be a fascinating trial. Very, very sad and heartbreaking thing. And I don't think any of us are going to be feeling great at the end of it, but it's going to be fascinating to see it all play out. All right, keep it rolling, Ritter. Keep it rolling.
Hey, Josh, it's therapist in West Texas. Most states still use some version of the M'Naghten rule. Massachusetts uses the McHoul standard. What's the real difference? And does that explain why Massachusetts supposedly has a higher success rate on NGRI? Thank you. Bye.
See, who's going around? Who's going around on a Sunday talking about the difference between M'Naghten and McHoul? None of my friends, tell you that much, and they're lawyers. Great question. TYK from West Texas. What is the difference between M'Naghten and McHoul? Well, not as big as you might think, okay? I know that a lot of people have pointed out they've got a different standard in Massachusetts. They use the McHoul standard, not the M'Naghten standard. I'll be honest with you, there's not a real huge difference between them. M'Naghten is kind of the general standard that most of the U.S. uses. Massachusetts, because they always like to be a little special, uses something different. They don't even call themselves a state. They call themselves the Commonwealth. They like to do things a little bit differently. M'Naghten asked the question, due to the mental illness or defect, mental disease or defect of the defendant, did they not know the nature or quality of their actions? McHoul says, due to the mental illness or defect, did they lack the capacity to appreciate the wrongfulness of their conduct or lack the ability to conform their conduct to the law? It's kind of a two-part thing that gets you to the same question. Could they not appreciate it, meaning the cognitive part of it, or could they simply not control themselves, meaning the volitional part of it? Well, even when you're using the M'Naghten standard, there's still a willfulness element in committing murder. You have to commit the murder willfully. So it's kind of baked into the cake. But they both get us to the same place. The big difference, though, between Massachusetts and most of the states is the following. One, Massachusetts uses what's called a substantial capacity understanding of their actions. So not could not appreciate, but could not substantially appreciate. And that kind of equivocation there gives a little bit of wiggle room for the defense. But I would argue the even bigger advantage to the defense in Massachusetts is the shifting of burden. In most states, when you're bringing a NGI defense, the burden is on the defendant to prove insanity. In Massachusetts, once the defense has raised that issue, the burden remains on the prosecution to prove sanity. So they still maintain that burden. That is not a small difference. That is a big difference. So those two things, substantial capacity and the shifting of burden or the non-shifting of burden, I think is what gives people an advantage in Massachusetts when they're bringing this type of defense. In any case, it's still going to come down to that same central question of the ability, the capacity to understand the quality, nature, and consequences of your actions. Did what you were doing was wrong? I'm trying to use the simplest language as possible. Did you know what you were doing was wrong? Did you know you were strangling your children and that in doing so, you might get arrested, your husband might get upset, you might get in trouble for this thing? Even if you were doing it because voices were telling you, even if you were doing it because God was telling you, even if you were doing it because you thought heaven would be a better place, even if you were doing it because you thought the alternative was awful, if you knew what you were doing would be a crime or get you in trouble or be wrong, that is considered sane for the purposes of the law. Not sane in practically any other venue, but sane as far as inside a courtroom. Great question, TYK. All right. If only Ritter could keep quiet, we could keep this moving along.
Hi, Josh, Tiff, Mods, and the lovely CC crew. This is Misbehaving from Sandy Acre, Nottingham. I saw you with Paul on Reporting Live from my sofa, and I was wondering if you could clarify a few things on spousal privilege. So, if the defendant waives spousal privilege for her defence, then obviously the Commonwealth has the right of confrontation. So is the husband on the stand allowed to refuse to answer a question from the Commonwealth, whether he is called by them first or just as a defence witness claiming spousal privilege? Or once waived, is it all waived? No, citing Mr. Bloodworth, takesies versus backsies here. Anyway, appreciate you managed to answer my question. Looking forward to the best part of Sunday. Ta-ra!
Misbehaving from Sandy Acre, England. Let's put you on the map. Great question. Thank you so much for watching that episode I did with Paul from what is it? Live from my sofa. Why am I blinking on this? Reporting live from my sofa. We had a great conversation about this. And one of the issues that came up is this idea of marital communication privilege, spousal testimonial privilege. They're kind of two very closely related but different concepts. And by the way, probably not going to be at play in this case because they're no longer married, we found out. But let's assume that they were married still. How would this all work? One, you've got the marital communications privilege. This protects any communication, and this is at play. While during the time that you are married, any confidential communication that you have between your spouse is privileged. This is held by the defendant. So I have a conversation with Tiffany. We are in a private setting when we have this conversation. I commit murder, and now she's testifying against me. She cannot testify to conversations that we had unless I allow her to do that, because I hold the privilege, so I would have to waive the privilege. If, however, I'm at my murder trial and Tiffany and I are still married and they call her to testify, she can say, I don't want to testify against my own husband. That is the spousal testimonial privilege. But she controls that. So she could decide, nope, Josh needs to go to prison, and she can decide to go ahead and testify against me if she decides to waive that. But she still can't say those private communications unless I waive that privilege. So she could talk about things she saw, things she witnessed, conversations we had in front of other people, but not to our private conversations. Here, that's not at play because They're not married, so they can compel him to testify. He's just a witness. They can subpoena him. They can put him on the stand. He can testify. It will only become an issue if they start to ask him questions about conversations he had with her in private, and she decides not to waive that. But I imagine that she will, because I imagine it's going to be helpful, those private conversations. She wants those to come out. One other note is that Massachusetts doesn't, again, because they like to be special, does not recognize this broader spousal testimonial privilege. So it probably wouldn't have played a role in this case anyways. But great question. Misbehaving from San Diego. Appreciate you contributing to the conversation. Reporting live from my sofa with Paul. There's the episode. Please watch it now. Not now, afterwards. Pantufel. We'll be okay. Help each other with respect and kindness. I know this is a tough one, guys. I know this is one of those cases that have got a lot of people really invested and really heated on both sides. And I'm going to just ask you to do your best to be respect and kindful and appreciative of other people's viewpoints, because it's not an easy one. There is most of the cases we talk about, there's a very clear bad guy. I don't think we had a lot of disagreement about Rex Heuermann. I don't think there was a lot of debate about whether or not we were happy to see Rex Heuermann go off to prison. I get it in this case that a lot of people, and myself included, like I said, when this is all said and done, conviction or no conviction, I don't think I'm going to feel all that great about it. So realizing all of that, I really appreciate how fantastic you've all been. Oh, Cardog Daniel says, Sofa show was great, Josh. Thank you so much, my friend. I appreciate you. All right, let's keep it rolling here. Oops, what am I doing? That was Kaylin's fault. All right. Here we go.
Hey, Josh, this is Wally from Rio Rancho, New Mexico. Was listening to your two-part series on the Idaho 4 murders on the drive home yesterday from Disneyland with the wife and kids. Question for you, maybe it's more of a comment or an opinion. However, first and foremost, I just wanted to say great work on that series, as always. Anyways, here it goes. Just going to rip the Band-Aid off. I don't think that death penalty eligible cases should be allowed to even have a plea deal available, if that's the right term. I don't know. Maybe I'm just saying that because I'm a parent. Maybe I'm saying that because I have a daughter who is going into her senior year in high school. Maybe I'm in the minority. I don't know. Anyways, keep up the great work. Appreciate you. Appreciate all that you do. And since I was driving home from Disneyland to Rio Rancho, New Mexico, which is about a 12-hour drive, not including California traffic, which props to you, my friend, with dealing with that, because that was insane. I'm only about 45% juiced today on my first day back at the office. Anyways, again, thanks for the great work. Thanks for the dedication to what you do and for putting in the care into such a troubling, disturbing case as the Idaho 4 murders were.
Wally, one of my dudes. Thank you so much, my friend from Rio Rancho. You just got me thinking. You are, what did you say? 45% juiced. Should we start selling like energy drinks? Is that what we should do? Like Courtroom Confidential juice? Is that where this whole company is headed? Is to just, we become an energy drink company? The girls are going wild for this. They love it. I think we should look into that. I think we should have our own branded Courtroom Confidential juice. It would help, my friend. It would help, Wally. Wally, thank you so much. First of all, you're a fantastic dad for driving 15 hours to go to Disneyland. So God bless. Secondly, thank you so much for the shout out to the special series we've been doing on Bryan Kohberger. We've done the first two parts. We're calling it After the Plea. The Idaho 4, Kaylee Gonzalez, Madison Mogan, Zana Kernodal, and Ethan Chapin. Part 1 was with Kevin Fixler. There's the link right there. Part 2 was with Joseph Scott Morgan, and there's the link right there. The next part coming to you soon. We can't announce it just yet, but we're working on it, and we appreciate you guys. We've felt it was important, and we've appreciated the response that we've received from all of you. And that got Wally thinking about the death penalty and how this case ended, and how it did end with a plea that ended without him receiving the death penalty. And should death penalty cases even be able to be negotiated? And I get it, my friend. I understand it. With the little ones myself, I understand it. The answer is obviously that, though, yes, they should. Because the plea, realize this wasn't a plea that came over the head or around the back of the prosecution. This wasn't something that they got away with, that they pulled a fast one, that they got themselves out of the death penalty. This was something offered to them by the prosecution. The prosecution was a participant in this. In fact, the only way this happened was from the prosecution. The judge didn't undercut them, which happens in some cases, not death penalty cases, but the prosecution said, we will take the death penalty off the table if he will plead guilty to everything, waive his appellate rights, and be sentenced to life without parole consecutively 4 times over. I get it. I was upset by it. I also understand why they did it. They thought to themselves, you know, there's when you get down to choices like this, you start to think, why are we pursuing the death penalty? Is it because there is something that this person needs to have their life taken by the state? Or are we trying to make a statement? Or are we trying to set an example? Not necessarily even bad reasons. Or is our goal in this to get a conviction, remove this person from our society for forever? And I think that's what they said. Our goal is that. Our goal is to remove this person from society forever, take no chances, have no appeals, and put closure to this whole thing. And that's why I think they did what they did. And they received a lot of grief for it. And I'm not saying that I'm even one of the people who didn't give them some grief for it. I felt robbed. So I can understand how the family members, or at least some of them did, and other people watching and other people invested in this. But it also is, I think, a very necessary part of our criminal justice system that the prosecutors should have the ability to do that if they feel it's important. So thank you again, Wally. I hope you're rested up. And thank you for shouting out that After the Plea series we've been putting together. All right, let's keep it rolling here. Oh, sorry. Yeah, let's do that. I'm sorry, Kaylin. Yeah. Sorry. Here's a little promo on that, by the way. He wasn't ever required to speak. He wasn't ever required to give any answers, to explain himself at all. What is your response to that?
He did not detail things like where the murder weapon was located or any sort of why, which is one of the things that members of the families and also untold numbers of members of the public want the answer to still today. The only person who knows the answer is Bryan Kohberger, and we're not sure he'll ever speak to these things. He hasn't yet, and maybe he never will.
The degree of brutality that was involved in her murder is the stuff of nightmares. Josh, if you and I were investigators and we just had one of these, you and I would have to step away, go get a cup of coffee or a scotch. All right. They did this 4 times.
Very proud of the work that we put into that. Kaylin did an amazing job, and we're very happy with the results so far and still working on it. So please check that out, guys. All right. Now I'm going to move on. And now I've lost my place. No, I haven't. Here we go.
Hi, Josh. This is Carol, the president of the East Africa Courtroom Confidential Crew. I'm calling you from my home in Ongata Rongai, Kenya. We were talking at our last meeting about this Lindsay Clancy case, and we were shocked to find out that Patrick and Lindsay are no longer married, that they're divorced. Is there some kind of legal benefit for him to have divorced her? Either benefit for him or benefit for her or something? He seems so supportive of her and seems to have her back and all. And so was kind of surprised that he had divorced her. And then today I learned or heard that he's remarried. So can you clarify how this works? Thanks for all you do. I appreciate your show so much. I enjoy it. Bye.
Carol calling in from Ongata Rongai, Kenya. Yes, you heard that right. She is president of our East Africa fan club out in Ongata Rongai. I'm looking at you, North Dakota. Carol put Kenya on the map, and I'm looking at you. Carol's listening from Ongata Rongai and asking incredible questions. Thank you so much for calling in. So, yes, I know that we went back and forth about this a little bit. People had early on heard reporting that Patrick had divorced her, that he had remarried. What's the story on all of that? You know what? I wanted to get in a definitive answer to all of this, and I knew that I was not the right person to just do it myself. So I do what I always did, and I phoned a friend.
Carol and Josh, thank you for having me on. Yes, Patrick Clancy has remarried. I learned that about a week ago, that he has married within the past year or so and divorced Lindsay Clancy. He has married reportedly a woman who is a fertility doctor, and he lives in New York. He will be, of course, one of the first witnesses to testify in this trial, and I imagine that he may be asked a little bit about his marital status. Josh would be the one to talk to you about the legalities of if this is a benefit or not. But as far as the criminal trial, I would imagine that both sides will use that to their advantage. The defense may likely say, look, he's moved on, he's married another woman, yet he's still standing by Lindsay Clancy. The prosecution could use that to say, well, look, he's really not standing by her because he's remarried and moved on with his life. If she is found not guilty, he's not going to be by her side taking care of her. He's moved on and left her. So it's an interesting development in the story, and one that I think will play out. We'll probably learn more as the trial proceeds.
There he is. The man, the myth, the legend, Nate Eaton from East Idaho News. Like that shirt, by the way. How do I get one of those shirts from Nate? That's what I want to know. There you go. Yes, he has remarried. He is remarried. I've heard that as well, that she is a, what did he say? Was she a doctor or a nurse? Something to do with a physician, right? I don't know. He just said it and I missed it already. Fertility doctor. So he's remarried. And he makes an excellent point about how this could come out both ways. I will tell you this. I think the prosecution needs to tread very lightly with this man. I do not see any advantage in them coming after him hard, trying to use the idea that he's divorced Lindsay as some sort of indication that he's turned his back on her. He's obviously been supportive of her. I think the smarter strategy is for them to just acknowledge that. You're standing by your wife. You had 3 beautiful children with your wife. You don't deny the fact that she killed them and that it ruined your entire life and everything else. And just lean into the idea of what this man is going through. Her attorney stood up and talked about how this man is able to survive and move on in the way that he has is just remarkable. And it is. And don't try to turn it into anything else. What you need out of him is what he witnessed, and leave it at that. I really think that would be the smarter way for the prosecution to handle it, because it's a real third rail tight wire act that they're going through if they try to turn him into anything more than that. But thank you so much to Carol from Ongata Rongai, Kenya, and from Nate Eaton from East Idaho. Still looking at you, North Dakota. We got Idaho and Ongata Rongai covered. All right. Let's keep it rolling here. I'm running out of time, aren't I? Okay, here we go. Oops. Ugh, Lord, get it together.
Hey, CC crew, this is Beth Rignell from Minneapolis. Happy Sunday Fun Day. I'm calling about Scott Peterson. I had watched the series on A&E, and I'm curious what type of evidence is needed to get a new trial, how much is needed to get a new trial, and statistically speaking, how often does that happen where evidence comes forward and, convicted criminals actually do get a new trial? It sounds like they had a lot of evidence that did cast some doubt, yet it's always denied. So just a little bit more information on how people get new trials. Okay, have a great day. Love you. Bye.
Beth from Minneapolis, Minnesota. Let's put you on the map. Yeah, this two-part series came out on A&E about Scott Peterson. Really interesting, definitely worth watching. And what they basically did is they took that new motion for a new trial from the LA Innocence Project. It's not the Innocence Project. It's the Los Angeles Innocence Project. They're different. They wrote a very thorough and exhaustive brief on a bunch of what they're characterizing as new evidence that should entitle Scott Peterson to a new trial. That was, spoiler alert, denied. The appellate court denied even a hearing on it. Now, I don't believe that's the end. I think they can still appeal that decision up to a higher court, and there's still habeas corpus things that can take place, but he's running out of options here. But many people took a look at that series, and I think it was done really well. My friend Chris Pixley was the one who was kind of heading it up, and I thought he did a fantastic job, though I don't agree with his conclusions, respectfully. I thought he did a fantastic job. But it begs the question of, well, if they've got all of this stuff, what is considered new evidence? Well, really what they had done is they had said, not that they have new evidence, but that they have new experts. They've got experts who can reanalyze the title conditions in the bay there. And they've got experts to talk about dog scent evidence. And they've got a new analysis of the aging of the fetus and things like that, but not necessarily what would be considered new evidence for the context of getting a new trial. New evidence for the concept of getting a new trial would be things, one, that were discovered after the trial. In some respects, they got past that hurdle, and others they didn't. And others, it was evidence they had at the time, they just decided not to use. Or it's stuff that could have been discovered at the time had they used reasonable due diligence. In other words, even if it's something that they found out afterwards, but they should have known ahead of time, not necessarily considered new evidence. It has to be material. In other words, it has to directly impact the verdict. It can't be just cumulative or just for the purposes of impeachment, which I think some of this new evidence fell into. But biggest thing of all of it is, would it produce a new result? Is it something so fantastic that it would produce a new result? And so after all of that, you say to yourself, well, what then is left? Well, it's things like DNA. It's things like they found DNA of another person that committed this crime, or a confession from somebody else who said, I did it, that can be independently corroborated and reliable. Those are the types of things they're looking for. What the court is concerned with is there something we simply cannot ignore? Something that shows this person did not do this thing. That's the type of evidence we're talking about. And I really just being honest and not trying to be all that controversial, I just don't think that they got to it in that special. And if Chris is watching, which I'm sure he's not, still did a fantastic job, my friend. All right. Now we are down to the final three. With just, ooh, I got to really hurry up here. With just the nick of time. All right. Let's keep it rolling.
Hi there, it's Dee, and I'm in Saudi Daisy, Tennessee, and I have a question about the Clancy trial. I know she can't because I don't think Massachusetts allows it, but if she were to be able to plead guilty but mental illness, would the judge in a situation like that allow for her to automatically be found guilty because she's saying she's guilty? I'm asking because I don't understand why they're going to go through the trial process to find her guilty when she's admitted to be guilty. It seems to me that that's just a cruel thing to put everyone through, but I'm sure there has to be a reasoning. And I don't know. I feel like if she had the ability to plead guilty but mental illness, it might make more sense to everyone.
D from Saudi Daisy, Tennessee. Great question. Yeah, why are we doing this? She admits she did it. She's just saying she was very sick. Shouldn't there be something like that? And there is something like that. There is a plea in some states where you can plead guilty but mentally ill. Now, the question though is becomes what does that have that all that different of a result? And the answer is not so much. Even when you plead guilty but mentally ill, you still go to prison, but you receive mental health treatment in prison. If she is convicted, Lindsay Clancy, and goes to prison, she will receive mental health treatment in prison. All of the prisons at this point are essentially hospitals as well. They're treating the mentally ill. They're treating people. I mean, she needs physical care on top of that. She's paralyzed, so she needs care. So she'll be treated in prison as well. But I think that your bigger question is kind of like, why are we going through this whole process when she's willing to admit she did the thing? She's just not willing to admit she had the requisite intent to commit the crime, right? Again, actus reus, mens rea. She's saying, I did the actus, I did the thing. I just didn't have the mens rea because I was sick. Shouldn't there be a plea to that? Well, the problem is, even if we had a plea, what do we do with someone like that? If you're asking to put someone like that into a mental health institution where they could be released one day, the state might have something to say about that. If you're asking to put them into a mental health institution where they would remain locked up for life, that might be a possibility. It all comes down to the state saying a crime was committed here, and we don't want this person out. We want this person to go to prison for the rest of her life. That's what they're looking to do here. Again, I don't know. I don't know if I feel good about any of it. I mean, I go back and forth. If she is convicted and she goes off to prison for the rest of her life, is she necessarily the type of person that we want off of the streets? Never committed a crime. Probably will be a wonderful contributing member of society if she's properly treated. But you got 3 dead babies that died in a horrific way. We've seen cases like this before. I mean, these are the types of cases you could go back and talk about the cars that have been pushed into rivers and the babies that have been drowned in bathtubs and all of the cases going back. These are always difficult every time they come up. And some of them are more hard to fathom in the moment than others. And I think this is one that's on the extreme end of being hard to wrap your head around and fathom and feel any way kind of good about. So thank you, Dee, so much. Oh, there you are. Thank you, Josh. I struggled to articulate my question, as sure you can tell you understood me completely. Oh, good. I'm glad. And I appreciate the question. All right. We're down to the end here, and I'm actually going to call this a two-parter question, all right? Let's see if we can accomplish this. For a first time here on Courtroom Confidential, we're doing a two-parter question from two different people.
Happy Sunday Funday, Joshua, Tiffany, Kaylin, our fabulous mods, CC family and guests, Alicia K. Mayo, Humboldt, Tennessee. All right, Joshua, I got a kind of two-part question for you. How common is a Kastigar hearing, and have you or one of your esteemed colleagues ever participated in one that you could tell us about? Now, Joshua, in all your upcoming adventures, I wish you plenty of Diet Coke and safe travels, and I hope everybody has a great Sunday Funday. Y'all hit that like button. Thanks. Bye.
All right, that was AKM from Humboldt, Tennessee, asking about a Kastigar hearing, and I thought a wonderful way to tie that up was with this question here.
What's up, y'all? Court Dog Daniel here. CC Crew. I know I'm out here covering the Lindsay Clancy trial, and that's what I'm supposed to be talking about. But sorry, I'm just going to have to self-flagellate again. Yes, therapists, you know, flagellate, not the other word. I wouldn't want to be doing that in the RV. So this one is about Oliver North, Wendi Adelson, and Kastigar. Stay with me here. So I'm lying in my RV fantasizing about a potential Wendi Adelson indictment. And if that ever happens, there's a good chance we get to watch a Kastigar hearing. So I went looking for the most famous Kastigar case I could find. There aren't many, but Oliver North is about as famous as they come. Here's a quick timeline of the case. This all happens between 1986 and 1990. Iran-Contra becomes public. Congress grants Oliver North use and derivative use immunity. He's indicted, and then he's convicted. And finally, in 1990, his convictions were overturned on appeal due to Kastigar issues. So to place this in perspective, this is 4 years before OJ. So the question is, why did Oliver North's Kastigar issues likely become a major issue after his trial and conviction? And how can Georgia Cappleman avoid that same outcome? This definitely needs some Attorney Ritter magic. 115 days until crime cruise.
I want you guys all to spend today somehow using Kastigar in a sentence and see how glazed over the looks on the face of the people you're talking with go. AKM from Humboldt, Tennessee, and CDD from New Britain, Connecticut. Your minds are aligned, both asking about Kastigar hearings. So I've got a couple of minutes left. I ran over what I wanted to do, so I'll do this as quickly as I can. What is a Kastigar hearing, first of all? Well, again, we talked about this earlier, that in when you're granted immunity, when we say granted, it's probably not a good word. When you have immunity foisted upon you, when you're forced to accept immunity and you give a statement, that is still considered a compelled statement. Well, the Fifth Amendment says that you cannot be compelled to incriminate yourself. So we have created this concept of immunity so that you're not incriminating yourself. You're being compelled to speak, but we're not going to incriminate you because we're not using it against you. That's use immunity. Well, I've also said many times that that doesn't mean that you're off the hook entirely. What if we're able to convict you or prosecute you for things derived independent from your statement? You tell police A, B, and C, but we use X, Y, and Z to prosecute you. Well, in those instances, they would bring what's called a Kastigar motion and ask for a hearing so that we could determine if all of the evidence that is being used against that person who had previously spoken to police with the grant of immunity in a compelled setting, if all of the evidence being used against them is in fact independent of what was said in that proffer or in that discussion and not derived from things. And it can get pretty intense. They have to really determine, hey, who knew about this? When did they know about it? How did they find this other piece of evidence? Was it, in fact, something that was independent entirely, or did they use a tip from that interview to put them along the pathway where they eventually found that piece of evidence? The idea, though, is it doesn't come up all that much. Yes, it came up in Oliver North, and they had a full-fledged hearing on whether or not things that he had said during a compelled hearing, but was later prosecuted for crimes related to that very same conduct, whether or not those things were independent. The Wendi Adelson example is great. She's testified now, what, 3 times, 2 times, both against her brother and her mother. And I think that was it, right? Just 2 times before. She's also spoken to police. So all of that was under grants of immunity, under use immunity. If she is eventually prosecuted, they're going to have to prove, and this is probably going to be no small hearing, they're going to have to prove that everything they're prosecuting her with is something that was independently derived and not something taken from information given to them through her prior testimony or compelled interviews. I hope that makes sense. I have exactly 30 seconds left to get you guys all out of here with some announcements, so I'm going to do them lightning quick. First of all, let me thank Lisa Scott for becoming a YouTube member. Thank you so much, Lisa. All right, Kaylin, get those fingers all stretched up. This one's going to go quick. First of all, let me tell you about thecourtroomconfidential.com. That is where you can go to leave us a message. If you would like to leave us a question for next week, go to thecourtroomconfidential.com and click on leave us a message. Everybody who received a membership, congrats. If you didn't receive one and you want to join up, then click on become a member and join the CC crew. And merch. If you're looking for your summertime merch because you live in the Northern Hemisphere, we've got you covered. We've got beach towels. We've got blankets. We've got, not blankets. We've got sandals. We've got pajama pants. We've got t-shirts. We've got koozies. We've got tote bags. We've got you covered at thecourtroomconfidential.com. And we also still have some hoodies and sweatshirts for those of you who live in New Zealand. What did you miss? We had the weekly rap sheet on Friday. That's the show that I do on Fox Nation with Donna Rotuno and Paul Morrow. We talked about the David case, Lindsay Clancy, Kendra Scott. Then we also had on Friday the weekly roundup back here on our channel where we talked about Lindsay Clancy, the David case, and Nancy Guthrie, plus our hero of the week. Please check both of those out. And directly following that, if you were a member of our crew in the classified and above, we had our members only live. That picture of me is absolutely ridiculous. That is, what is that look on my face? That's not even like a real person's smile. That is so funny. All right, then stay tuned next week, all next week on Courtroom Confidential Live Trials. That's our sister channel where we put all of our live trials. We have the Lindsay Clancy trial. So opening statements on Monday. Tuesday, they go dark, but then we'll be following it for the rest of the week. To get set for this, please watch our 5 Things episode on Lindsay Clancy. 5 things you should know going into this trial. It's called Planned or Psychosis. Please check it out. It's on our channel now. There's the link. On Monday as well, we will be having our Monday night special with a new guest. This is Boston criminal defense attorney Elise Hershon. She's been on local news there in Boston, plus NBC, CNN, 5 p.m. Pacific, 8 p.m. Eastern. She's going to be helping us walk through opening statements and what to expect in this trial moving forward, because I think she knows all of the parties involved. Tuesday, we are having our Wednesday show on Tuesday. So we're not going to have a Wednesday show. We're going to move it to Tuesday instead because we got to move some things around this week. So that will be at 5 p.m. Pacific, 8 p.m. Eastern, guest to be announced. Then no show until Saturday. So Wednesday's moving to Tuesday, Friday's moving to Saturday. Saturday will be at 10 a.m. Pacific, 1 p.m. Eastern. That will be our weekly roundup on Saturday. Hope that all makes sense. We'll probably tell you this all again on Monday. Crime Cruise is coming up November 18th through 22nd. If you would like to join us, along with myself and Matt Murphy, Chris Hansen, Dr. Catherine Ramsland, and our good friend Nate Eaton, we'll all be on a boat together trying to survive. Enter the code Ritter, all caps, all one word, at checkout for 10% off. You are all fantastic. Big shout out and big thank you to my friend Nate Eaton for helping us out with the Phone a Friend today. Big shout out and thank you to the best mod squad on YouTube: Afton, Sonia, Kathy, Therapist Best Nancy, and Becky B. Kaylin, you're fantastic and you're quick on the draw. Thank you so much. Tiffany, you're the best thing that ever happened to me. Take care, everybody. Bye-bye.